Welcome to our webinar, Wage and Hour, Misconceptions that Lead to Misclassification and Exposure. This presentation will last about 30 minutes, and a recording of the webinar will be available on the Wagner Law Group website shortly. You can access the previous webinars on the website as well. Let me introduce our speaker, David Gabor. David is of counsel with the Wagner Law Group in Boston. Welcome, David.
Thank you, Barbara, and hello, everybody. Thank you for joining our program today. About a month ago, I decided to do this program after talking with several colleagues, clients, and people in the legal community about wage and hour and misclassification of employees because of the many cases that have come down in this area of law and the misconception that many employers have about the difference between an exempt and non-exempt employee. So I started to put my materials together, and as I do every day, I look at headlines in the legal field. And on November 5th, there are three major headlines about wage and hour and employee misclassification. The first concerns GEICO, which instead of saving a bunch of money on its car insurance, saved a bunch of money by escaping a collective action in an overtime case involving misclassification. And Wells Fargo was successful in denying class certification in the case. Now, don't believe that GEICO and Wells Fargo are happy because they won the cases. Yes, they're happy about that, but they had to pay enormous sums of money to defend these actions and had a tremendous disruption to their workforce and the business that they're in. At the same time, New York Hospital had to pay $1.5 million to settle a meal break suit. In fact, there was 3 class actions that they had to settle. We're going to talk more about meal breaks later. So that's the headlines from November 5th. And what about November 4th? A judge approved a $7.5 million settlement in a senior living case. This involved 3,300 resident managers who were misclassified as exempt. A jury awarded $1,960,000 in a case involving KBR Inc. And this case out of Iowa was involving overtime that was not paid to employees at a corn process plant. That does not even take into consideration the amount that will be paid in liquidated damages and counsel fees. More about that later. A tip for Marriott: pay the tips to your employees. A federal district court in Hawaii found that Marriott was pocketing portions of the gratuities left in customers' checks and not giving them to the food and beverage workers. Finally, a case was brought in New York City by a court clerk on behalf of herself and 1,400 other court clerks. So what do we learn from these headlines? We learn that employers are still not doing enough to protect themselves in these wage and hour claims and audits. Some suggestions right from the get-go. No pun intended for GEICO when I said that. Get educated. Ask questions. Ask questions of HR, of supervisors, of your accountants, controllers, your lawyers. Don't make assumptions. Well, this is the way we do it. It's fine. If we do it this way and it worked in the past, it will work in the future. Review the classifications you use to distinguish between exempt and non-exempt employees, and confirm that people do, in fact, what it is that's specified in the job descriptions. Oftentimes, a job description says one thing, and they're doing something very, very different. If we don't do this, the cost is an awful lot greater than what was paid out in some of the cases we talked about. And then even if the employer is granted a summary judgment and the case is thrown out, it's a huge disruption if a case is brought by current employees. Imagine the tension that creates in the workplace and the impact it has on your business. You're paying legal fees. Defense fees are enormous. Then if you lose, the employees get prevailing legal fees. So you're paying double, if not more. You face the risk of liquidated damages, which are equal to 1 time the money that's owed to people. And we're going to talk about ways to handle that in the program as well. You also are looking at interest. And finally, publicity. The general rule of thumb is that some employees are entitled to overtime because this is what's guaranteed to them in the Fair Labor Standards Act, FLSA. However, employers are not obligated to pay overtime under the FLSA to exempt employees. And as a caveat, keep in mind that states have their own overtime laws. Please keep that in mind as you develop and you disseminate your practices. The recurring theme in this area is that employers mistakenly believe that certain people are exempt when, in fact, they are not exempt. And that's one of the themes we're going to talk about. And this is one of the things that, as you leave the program, follow up on in your company and with the professionals that you work with. Another thing that's happened, and I've heard this so many times, is sometimes employers say, gosh, I never thought that Laura would bring a lawsuit. Laura is loyal. She would never bring a claim against the company. Or John would never bring a claim against the company. Please don't make that mistake. So let's talk about who is exempt. We start by workers in bona fide executive, administrative, or professional capacities. This could also be a designated skilled worker. The person must have a primary duty that directly relates to the management or general business operations of this business or of its customers. An exempt employee is one who exercises discretion and independent judgment, is paid more than $455 a week. And typically, this is someone who supervises 2 or more people. The burden is on the employer to prove that an employee is exempt under the FLSA. And such exemptions are to be narrowly construed against the employer seeking the exemption. This is the law. This means that the employer has got to demonstrate that the person is exempt. Typically in lawsuits, the burden is on the plaintiff. In these cases, it's on the employer, and that's a big distinction. Now, it's more than just what the person's job title or what the job description entails. And here's a challenge I've got for you. And if you want to have some fun, present this challenge to your colleagues. I challenge you to find an employee who does not do what is actually listed in the job description. This could be inside your company, a family member, a friend, a colleague. And I bet it's not too easy to do it. Let's go a step further. Let's use the name John. I bet you can find somebody named John whose actual job is different from what the job description for that person provides for. So why is that important? Because many, many cases I have handled have been brought because the person does not do what's in the job description. And the courts and the Department of Labor don't really care about the job description. They care about what the person actually does on a daily basis. The law says about a non-exempt employee, the amount of pay due an employee cannot be determined without knowing the total number of hours actually worked by that employee in each work week. An employee must be paid for all of the time considered to be hours worked, and all time that is hours worked must be counted when determining overtime hours worked. And the problem in these cases oftentimes is the employer fails to properly pay the non-exempt employee for all of the hours worked in accordance with the federal and state laws, or the employee misclassifies an employee. Now, assuming for a moment that the employers are trying to get it right, why are the mistakes happening? And that's part of what we need to examine in the program. And in a few moments, we're going to talk about some real-life cases. And with one exception, these are all 2013 cases I'm using in this program. So even though wage and hour cases have been going on for decades, the mistakes are still happening. And as I've mentioned before, the cost to the employers when they make these mistakes is significant. Back pay, that's the amount of overtime that was not paid. Liquidated damages. If the employer is acting in bad faith, is willful, isn't trying to get it right, the employer is subject to paying twice the back pay because they've got to pay liquidated damages equal to back pay. And interest, which can amount to a lot of money, and legal fees. If you lose, you're paying your fees and the plaintiff's fees. So a lot of the recent cases that we are going to talk about concern meal breaks, recognizing when the workday starts and ends, sloppy agreements, poor internal control by companies, and poor record keeping. The meal break is something that is very clearly defined in the FLSA. A meal period is a time when the employer does not have to pay the employee if the employee is completely relieved of duty. That means that the employee must not perform any duties at all that are work-related during that time. One of the tests used by the courts in meal break cases is if the time is spent predominantly for the benefit of the employer. So notice, the employer has constructive knowledge. If the employer had a reason to know or should have known that the employee performed uncompensated work during the break. So if the employer has no idea at all that the person is working, no idea whatsoever, the employer has got a good chance of not being held responsible for paying for time spent during the meal break. But if the employer had a clue, even a very small clue, that work is being done, then the employer is responsible. Let's suppose for a moment that the boss steps out of the office, walks past an admin's desk, and there are a pile of files on that desk that need to be put away. The employer comes back in an hour, and during that time that the employer was gone was the same time the employee is taking lunch. The employer comes back, and all the files have been filed. The employer didn't see the employee put the files away. The employer was not told by the employee, I put your files away. But the employer had constructive knowledge that either one of two things happened. The employee put the files away, or it was magic, and the files magically were put away. The court is more likely to believe that the employer had constructive knowledge as opposed to it was magic. So don't just think that by burying your head in the sand like an ostrich, you can get away with it. Let's talk about when the clock starts. The Supreme Court held, and this was actually a long time ago, that physical or mental exertion, whether burdensome or not, controlled or required by the employer and pursued necessarily and primarily for the benefit of the employer and his business is work. So we're going to talk about a case called Abadir versus Tyson Foods. And this just came down a few weeks ago. The employees at the food processing plant would clock in when they first arrived to work. Okay, so what's with Gabor? Why is he talking about a case? They clocked in when they arrived at work. What's wrong with that? The clock they were punching in on was an attendance clock, not the clock for purposes of paying them for the time they worked. After they clocked in on the attendance clock, they had to retrieve and don a sanitary frock. They had to retrieve and don sanitary hairnets and hearing protection. Then they had to go get the position-specific equipment they needed to perform the job. Then they had to take the equipment with the frock, with the hairnet, with the hearing protection, down a couple of flights of stairs. And they had to wash their hands. Now I finished the slide. Do you think that's everything they had to do before they punch in? No. There's more. They had to walk through a sanitizing foot bath onto the production floor. They had to sanitize all the non-fabric items that they had with them. They had to then don all these non-sanitized, non-fabric items. Excuse me, they had to don the sanitized non-fabric items. They had to collect and don the gloves. Then they had to prepare the work area. Maybe it's bringing labels to put on the food. They had to wipe down the workstations and other things they had to do to prepare. And they had to arrive at the workstation by the pay start time. And then they started to get paid for the day. So these workers got a little upset and said, we're doing all this other stuff here we're not getting paid for. That's wrong. The court agreed and held that the act of donning and doffing the frock serve as the beginning and the end of the employee's compensable workday, making all other activities performed in the interim compensable under the continuous workday rule. Then we have sloppy, sloppy, sloppy. Communication. Good, strong, clear communication between employers and employees is critical. If you've got an agreement, write the agreement in a way that you understand it to be, that the employee understands, that the Department of Labor understands, and a trier of fact can also understand, so that everyone reads the terms of this understanding the same way. Some people I work with are in medical, others in IT. Whatever the field you're in, write so that people outside of your field draw the same conclusion. So we have a meeting of the minds. In the Ingersoll-Rand case, a class action case was brought, and Ingersoll-Rand lost on summary judgment trying to throw the case out because there was a difference of understanding about a shared general expense. This was a policy that the employee said, was taking away commissions that they earned. And the employer was saying, no, we're not taking away anything that you earned. We're sharing our expenses that we incurred so that you can go out and sell. Well, they did not have any express agreement. And the court was satisfied that absent the express agreement and the plaintiff's claim for commissions, that this case can go forward as a class action. And that should never have been the case if they had done the mere simple little thing, i.e., properly communicate. Oftentimes, it comes down to inadequate or poor internal control. And on things like meal breaks, you can avoid this by making it very clear to the supervisors. Expect your employees to actually be relieved of duty when they take meal breaks. No ambiguity, no uncertainty. Make it clear. When you are on a break, take your break. And make it very clear in our expectations to the supervisors of what we expect of them as well. So the message they're giving the employees is consistent with company policy. And then follow up. Walk the floor once in a while. Make sure that people are taking their breaks, that they're relieved of duty. Don't just assume it's happening. Get out there and check. Have an overtime policy. There is no room for ambiguity. Have a pronounced overtime policy that speaks to what your employees, regardless of who they are expected to do. Make sure the job descriptions are accurate. So many cases are brought because people are not doing the same job that's in the job description. Take the time to read the job description. Then find out if that's what the employee is doing. It's not a complicated process. Go to the supervisor. Is Larry doing what's set forth in the job description? And if you're not sure, talk to Larry. When employees have a change in responsibilities, that may mean that they are no longer exempt from overtime. So if there's a change in responsibility, follow up. Make it very clear who can authorize overtime, who can authorize a change in a responsibility. You know, if a supervisor decides to change the responsibilities for an employee, make sure that only happens after HR approves it, because we want to avoid inconsistent management of these employees. I talked about liquidated damages, and one of the ways to get around liquidated damages is your record keeping. Think about what you need to have to demonstrate that your company has made every reasonable effort to properly classify its employees and pay them for all time they're entitled to. Your policies, your time records, your training programs, establishing who attended the programs, having acknowledgments from employees, all help defeat liquidated damage claims. Now let's look at some cases. In the Schmidt case, which is about whether or not a person is an outside salesperson, outside salespeople are exempt from overtime. Inside salespeople oftentimes are not exempt from overtime. So in this case, the court looked at where the primary duty was. And in this case, 4 to 8 hours a day was spent outside the office. And much of Schmidt's in-office time was spent furthering her sales efforts. She was working on her marketing plan. She did promotional work. She was trying to create more appointments for herself. The court also noted in the Schmidt case that there can be a combination exemption, part administrative and also part outside sales. So Schmidt lost her case. Eagle Waste had good records that was that they could use to establish that she was out of the office 4 to 8 hours every day and what she did in the office. That helped them win that case. In the Gold versus New York Life case, this was actually an interesting case because Gold said he's not being paid for overtime. And he's entitled to overtime because he was, even though he was solely a commissioned salesperson, some of his work was giving financial advice. And he argued and reasoned that financial advice was not primarily sales work. You know, he was making investment recommendations, and he thought he can get his commissions and overtime on top of it. So let's talk about the analysis. In September this year, the Second Circuit found that the primary duty is making sales or obtaining orders on contracts for services that customarily and regularly engaged away from the employer's place of business. That his primary duty was selling the insurance. And the overriding factor, more than anything else, was not his title, but it was what he was doing. So they held. By distinguishing between two kinds of people, the outside salesperson, where the agent is primarily selling, and the administrative employee who is primarily providing the service for the insurance products already purchased and who occasionally makes a sale. So Gold did not find his pot of gold in his lawsuit, and he lost. There's an old song from Bob Dylan, "The Times They Are Changing." And this is an important thing to keep in mind, and I know I mentioned it earlier, but it bears repeating because it comes up a lot. In tough times, companies sometimes downsize, and there are less people working in a given department. Let's talk about Laura. She's a supervisor. She's got 4 staff people who report to her, and the company has cutbacks. She's got 3 people. She's got 2 people. She's got 1 person, only 1 person. And if she only has 1 salesperson or 1 employee working for her, she is no longer deemed to be an exempt employee. She's not managing 2 or more people. FedEx tried to defend a case by saying the employee's subjective belief that he was exempt means he is not entitled to overtime under the FLSA. Court said, no, FedEx, you're wrong. In fact, employers cannot skirt their FLSA obligations to pay overtime by obtaining waivers from employees. The court said, we're not going to open that door and go down that road. I have a question on this one. How do you think the court sent the decision to FedEx? Do you think they sent it by overnight? Another case was brought, which is an interesting case, by some former fire district chiefs in Jackson. And they said that they can get away with bringing their case claiming an entitlement to overtime even though they supervised people on a regular basis and even though they were paid more than $455 a week. There was a threat that they might end up having deductions taken out of their pay because of a policy that was created by the city. However, the city never did deduct pay from them. The city never did enforce the policy, and the court said, come back to us if, in fact, your pay is deducted. But until then, you've got no basis to be in court. Your case is not ripe. So we've got some takeaways on this program by talking about the area of law, by talking about the distinction between exempt and non-exempt, and the types of cases that are being brought today. I am hoping that this opened your eyes, that this is something that could affect your company, your friends, and your colleagues, and that it is important to be proactive. Ask questions of HR, of supervisors, of employees. Review your policy manuals. Review your protocol. Check with the professionals surrounding you. And make sure that what you have as your understanding of exempt versus non-exempt is correct. Make sure that your understanding of when the workday begins for each of your employees is correct. And make sure that your employees are being paid what they're entitled to be paid. And the better your lines of communication, the more you have a culture where the employees believe that you're trying to get it right, the less likely they are to bring cases, and if they do, your cases can be defensible. I very much thank you for taking the time to join us in this program, and certainly would be happy to answer any questions that you've got. And in fact, if you want to send an email regarding the challenge to find a person, especially a person named John, who is not doing what is in the job description, by all means, feel free to email me your feedback. Thank you again.
David. That was very informative and entertaining. And thank you to everyone for attending this webinar. A recording will be available on the Wagner Law Group website shortly. And please feel free to contact David if you have any questions. Thank you very much.